Hello, everyone. Welcome to Season 3, Episode 14 of ARBinBRIEF, a practical video guide on handpicked arbitration issues. My name is Aseel Zimmo. I'm an independent arbitrator and disputes lawyer based in Bahrain, and I'm part of the ARBinBRIEF team. I'm very excited to moderate today's episode. A few words on ARBinBRIEF, which is a practical video guide on handpicked arbitration issue with talented and diverse arbitrators in an interview format. Now, in today's episode, we will be discussing the topic, can't pay, won't pay, how to deal with non-paying claimants and respondents. This topic was inspired by the latest jurisprudence of the Polish Supreme Court and the decisions out of the Dubai Court of Cassation on costs in arbitration. I'm very happy to say I'm joined today by two amazing arbitrators, Amanda Lee, arbitrator at LML Arbitration and consultant at 𝗔𝗥𝗕𝗙𝗥𝗜𝗙 based in London, and so Soraya Corm-Bakhos, counsel at Watson Fairley and Williams based in Dubai. Thank you both for joining me. Mandy and Soraya will explore four main areas. First, the circumstances in which parties may fail to pay arbitration costs. Two, how arbitrators can ensure that non-paying parties are treated fairly. And three, lessons for arbitrators from how courts treat non-paying arbitration parties. And finally, and most excitingly, I think, practical examples of non-payment and how to handle them. Let me start with Soraya. Can you share with us, Soraya, situations where the respondent would not pay its share of the arbitration cost?
Yes, sure. Hello, everyone. So in my experience, there are essentially two kinds of situations where respondents will not pay their share of the advance on costs. So first, you have the situations where respondents raise jurisdictional objections and or believe that, the claims they are facing are entirely without merits, and they take the stance, rightfully or wrongfully, that they shouldn't be paying. Second, you have respondents who then totally in bad faith simply, even if they have the mean, decide to derail the proceedings by not paying. Now, in such cases, the claimant will have no option but to substitute for the respondent's share in order for the arbitration to proceed. Now, when that happens, there are two things that the claimant in that situation should think about. First, make use of the provisions of leading arbitration rules, such as the ICC or the 𝗔𝗥𝗕𝗙𝗥𝗚 rules, for example, which allow the claimant to provide a bank guarantee for the substitute payment rather than having to pay in cash, or provisions such as those in the LCIA rules or the latest edition of the ICC rules, which allow claimant in such situation to ask the tribunal, once constituted, to immediately issue an award for reimbursement of the monies paid by the claimant on behalf of the respondent. And tribunals do not hesitate, when receiving such application to proceed, because the underlying assumption here is that the failure by a party to pay its share of the arbitration costs amounts to a breach of contract.
Thank you, Soraya. Mandy, would you share with us examples in the more unusual circumstances of a non-paying claimant?
Of course. Claimants may face unexpected and unwelcome calls for further funds in two key situations. First, if the respondent is unable or unwilling to pay its share of an advance or fee. And second, if the respondent chooses to bring a counterclaim, particularly if its value significantly exceeds that of the original claim. Whether the claimant is unwilling or unable to pay the respondent's unpaid share in respect of its claim or its own share in respect of a counterclaim, the result is the same. The tribunal must consider whether to permit the underlying claim or counterclaim to proceed. And the same issue may continue to arise as and when further advances or fees are requested. Ad hoc proceedings can also present problems, mindful that parties will typically be agreeing terms with the tribunal itself, and that can raise practical issues, particularly if parties are unrepresented or unfamiliar with how much arbitration can cost, and agreement cannot be reached. Basically, non-paying claimants are just as likely to keep tribunal members on their toes as non-paying respondents.
Absolutely. Thank you, Mandy. Mandy, would you talk us through the latest Polish Supreme Court case on the issue of non-payments of arbitration costs, and particularly about how the court dealt with the question of how the lack of financial resources to conduct arbitral proceedings could be considered as a breach of the principle of access to justice?
Absolutely. Well, parties from Poland and Luxembourg had entered into an arbitration agreement, but the claimant was unable to pay the costs associated with commencing arbitration proceedings. The claimant sought to argue if a party lacked the necessary funds to pursue arbitration, the effect of such impecuniosity may be to render the arbitration agreement invalid or unenforceable. Now, the Warsaw Court of Appeals rejected that argument, holding that parties were responsible for ensuring they could cover the costs of arbitration. However, in its decision of January 2024, the Supreme Court drew a distinction between invalidity and unenforceability of an arbitration agreement, considering Article 6.1 of the European Convention on Human Rights and Article 47 of the Charter of Fundamental Rights of the European Union. The upshot: although a party's objective financial inability to pay arbitration costs does not invalidate an arbitration agreement as a matter of Polish law, it could result in such agreement being unenforceable within the scope of Article 1165 of the Polish Civil Procedure Code. The arbitration agreement here, although valid, was unenforceable. Although the Supreme Court recognized that the decision to arbitrate was an expression of autonomy, the effect of exercising that autonomy could not be to completely prevent a natural person from accessing justice. And it distinguished here between natural persons and legal persons. And in this case, involving a natural person who could not afford to commence arbitration, the result of enforcing the arbitration agreement would be to deny judicial protection to that claimant. It recognized, however, that declaring an arbitration agreement to be unenforceable due to a party's financial impediments should not be done lightly. After all, applicable arbitration rules may allow the other party to pay costs instead, or for them to be temporarily assumed by an institution or otherwise mitigated. If financial impediments are removable, an arbitration agreement may be enforced. And although courts generally reject unconscionability challenges related to fees, the Polish Supreme Court is not an outlier. Numerous US courts, for example, have acknowledged that arbitration costs may be prohibitive or represent a significant financial disincentive to a party exercising its legal rights. So where does this leave us? Well, many domestic court systems make financial support available to parties, whether in the form of legal aid or fee waivers. Such support is less widely available in arbitration, although legal aid funding is available to natural persons from, for example, the Court of Arbitration for Sport. Parties contemplating arbitration may also be able to obtain financial support from third-party funders. It remains the case, though, that parties who've agreed to submit disputes to arbitration do face a financial burden, even if a party feels comfortable representing itself. Initiating arbitration typically requires the payment of fees. And as with all things in life, we need to strike a balance between the need to honor the party's carefully made choice to arbitrate and ensuring that financial limitations do not prevent parties from accessing justice, particularly when the claim they seek to advance may actually be the cause of their financial limitations in the first place.
Thank you, Mandy. We need to continue watching that space. Soraya, the Dubai Court of Cassation also has got a number of decisions relating to the question of non-paying claimants and respondents. Can you please tell us about those cases? And has there been a shift in the court's approach on this matter in the last couple of years?
Sure, yes. There has indeed been a recent shift by the Dubai Court of Cassation on this point. So the reported UAE cases all involve 𝗔𝗥𝗕𝗙 proceedings, where either none of the parties pay its share of the advance on cost, or it is the respondent who fails to pay and the claimant doesn't substitute. So when this happens, 𝗔𝗥𝗕𝗙 closes the file and considers the claims withdrawn. The claimant or the respondent then goes and files the case before the local courts. Now, until recently, the UAE courts considered that in those scenarios, the arbitration agreement becomes inoperable or invalid because its purpose had expired when the proceedings were discontinued, and as a result of that, the courts would accept to cease jurisdiction. So that is the approach which was taken, for example, in a decision rendered in 2019, in which the court decided that, because of the parties' respective failures to pay, the arbitration clause was void, and the claimant then is entitled to have recourse to the Dubai courts, which have the original jurisdiction, as the court put it, because traditionally in the UAE, arbitration was considered an exceptional means of dispute resolution. Now, in that case, the Court of Cassation took into consideration that following closure of the case by 𝗔𝗥𝗕𝗙, the respondent had not objected to the decision that the case be considered postponed, and no action was taken by the claimant to resubmit the case to arbitration. Now, in a more recent case in 2022, the Court of Cassation appears to have changed its approach. In that case, the claimant filed the proceedings before the court, arguing that the respondent waived the arbitration clause, by failing to pay, and also because it had challenged the jurisdiction of the tribunal and the validity of the arbitration clause. Now, the Court of Cassation dismissed those arguments this time and explained that the respondent had, in fact, engaged in the proceedings by agreeing to a 3-member panel, appointing its arbitrator, and agreeing to conduct the proceedings in English. Now, and also the court noted that the challenge made by the respondent to the arbitration was on the basis that the condition precedent to arbitration had not yet been fulfilled. So the Court of Cassation said there was no bad faith conduct by the respondent nor a waiver of the arbitration clause, and the claimant in those circumstances, cannot avail itself of this waiver argument, and especially when the court said the claimant had the option to pay the respondent's share or provide a bank guarantee, in line with the applicable 𝗔𝗥𝗕𝗙 rules. And in that case, the court did not agree to seize jurisdiction. Now, this shift in approach has definitely been confirmed by an even more recent ruling dated 8 June 2023. And now, in that case, the court, relying on various provisions of the federal arbitration law, held that 𝗔𝗥𝗕𝗙's decision to close the case file for non-payment of arbitration costs, one, does not result in a failure for, invalidity or otherwise of the arbitration agreement, as long as no arbitral award is issued. Second, doesn't mean that the arbitration clause was waived. Third, doesn't prevent either party from resubmitting the claims to 𝗔𝗥𝗕𝗙 at a later stage, and does not deprive a party of a right to invoke the arbitration clause before the courts. Therefore, the court jurisdictions remains excluded as long as the arbitration agreement is valid and enforceable, notwithstanding the party's failure to pay its share of the advance on costs.
Thank you very much, Soraya. Now, ladies, let's move on to your tips on how to handle some common situations of non-payment. Mandy, I always find it difficult when sitting as an arbitrator in ad hoc proceedings to agree on tribunal fees, and even harder when I sit as a sole arbitrator. How do you deal with that situation as an arbitrator?
Well, arbitrators may initially find themselves sitting in lower value ad hoc proceedings involving unrepresented parties, and such parties may have never dealt with arbitration before and may hope never to do so again. And reaching agreement on fees makes payment more likely, and the Chartered Institute of Arbitrators guideline on terms of appointment and remuneration is a good place to start. Make sure that you agree how your fees will be calculated, whether cancellation or commitment fees will apply, which expenses will be recoverable, how taxes will be addressed, whether advances will be payable, how often invoices will be sent, and when a final account will be submitted. You should also make appropriate arrangements for payment if the case is settled or terminates early. Having a reasonable benchmark is helpful. For lower value claims, I have, for example, used fixed fees charged by institutions as that benchmark, and likewise in higher value cases, I've used hourly rate guidelines for arbitrator remuneration published by arbitral institutions such as the LCIA as a reference point. And of course, record everything in writing and obtain party agreement in writing.
Absolutely, thank you. So, Soraya, Mandy explained how she dealt with agreeing tribunal fees in ad hoc proceedings. This issue becomes harder, doesn't it, when the relief sought is non-financial in nature? How would you deal with a situation like that?
So in relation to non-financial relief, so I have the experience of that in institutional arbitration. So non-financial relief, is essentially when the parties are not claiming monetary damages, but they are seeking a declaration or orders for specific performance. Now, under the 𝗔𝗥𝗕𝗙 rules or the ICC rules, for example, the institution will always, ask the parties to quantify their claims. And so, for example, we currently represent a client in a 𝗔𝗥𝗕𝗙 case who is seeking an order for a forced transfer of shares in a joint venture dispute. And we were required, to give a figure in order for the institution to calculate the advance on cost. And so we assessed the value of our non-financial relief by reference to the value of the underlying shares. In another case, this time an ICC one, the claimant's request for relief included both monetary and non-monetary relief, because actually I think it's very rare that you would only have non-monetary relief. There will always be some part of the claim, for damages. And so when the institution look at your relief sought, and it will generally consider, the value of the monetary relief only, and then quantify the advance on costs. I guess it's easier in institutional arbitration than in ad hoc arbitration.
Thank you. We have two more circumstances to go through, and we've got a few minutes. In circumstances that you mentioned, Mandy, when the case settles or the claim is withdrawn, how have you dealt with the issue of fees?
Well, proceedings may settle, or it may come to light that the respondent is impecunious, following which the claimant may choose to discontinue, and that can raise payment complications for the tribunal, depending on the terms agreed and the stage of the proceedings reached. Parties may, for example, argue that an arbitration was not technically commenced, although many arbitration laws and rules quite clearly spell out when an arbitration actually commences. It's also difficult for a party to argue that the tribunal should not be paid if certain steps have been taken, such as, for example, filing pleadings. Remember, however, though, as arbitrator, you must remain independent and impartial. Whether sums are due will be a matter of contract and application of the applicable arbitration law. There's no need to get into the ring, as it were, and start arguing with the parties about this. You may, however, face the somewhat surreal task of drafting an award on costs that solely deals with your fees, in circumstances where there is probably going to be a significant risk that neither party is going to pay, regardless of what you actually award. That's always fun.
Thanks, Mandy. I'm sure that's a very tough situation. Soraya, finally, in all events, the winning party's ultimate concern is to get paid and recover the cost of arbitration, including tribunal and counsel fees. How has the Dubai courts dealt with the issue of recovery of costs by the winner?
Well, that is a hot topic in the UAE, because there has been a very unfortunate new case rendered in February this year, which was widely reported, in which the Dubai Court of Cassation set aside an ICC cost award. And the court considered that the tribunal exceeded its powers in ordering payment of the successful respondent's legal costs. Now, I think to understand the decision or put it in context, one should recall that under UAE federal arbitration law, there is no express power granted to tribunals to order legal costs, but simply a reference to arbitration expenses. And the definition of arbitration expenses does not include a reference to legal costs. Also, under the old 𝗔𝗥𝗕𝗙 rules, this reference to legal costs in the definition of arbitration costs was also lacking, and this has then allowed the Court of Cassation to confirm in several cases that in the absence of parties' express agreement to give the tribunal power to award those legal costs, then a tribunal sitting, in Dubai under the 𝗔𝗥𝗕𝗙 rules did not have that power. But now the February 2024 case is a bit surprising, considering the express wording in the ICC rules in Article 38.1, which state that cost of the arbitration shall include the fees and expenses of the arbitrators and the reasonable legal and other costs incurred by the parties. So now, how can parties mitigate, this potential risk of, ICC cost award being set aside? Then parties should make sure, that either, your original arbitration agreement should include express wording empowering the tribunal to award lawyers' fees, or under the ICC rules, you have to make sure that the terms of reference, which are a mandatory feature of ICC arbitration, clearly confirms the tribunal authority to award legal costs.
Thank you, Soraya. Now, thank you very much, Mandy and Soraya, for this incredible, insightful discussion. I'm sure we could have discussed this for many hours, but unfortunately, we have to end it there. The useful tips that you gave us to deal with these challenges would be very useful. I certainly learned a lot. At this stage, I comes to thank our partners, organizations, ARBIPledge and the Lagos Chamber of Commerce International Arbitration Center for their invaluable support in making Season 3 possible. We are also truly grateful to many organizations that support the marketing of our series around the world, Arbitral Women, Careers in Arbitration, and the Rising Arbitrators Initiative for their invaluable support. For those of you who are watching us over YouTube, our video ends here. Thank you for joining us. To see future ARBinBRIEF videos on handpicked arbitration issues, please follow us on LinkedIn and like and subscribe to our channel on YouTube. We would love to hear your comments and feedback, and you can register for our next episode on www.arbinbrief.com. We look forward to seeing you there.